I overheard my son-in-law screaming at my daughter, "Get this sick old fool out of our house before he ruins everything for us." To my horror, she nodded and threw me out, her own father. I quietly packed, took my $15 million fortune, and walked away. Then I watched them panic, drop to their knees, begging for what they had already lost forever. Before continuing, subscribe to our second channel. You can find the link to it in the description of this video, in the comments, or just click the subscribe button. Thank you. My name is Ralph Montgomery. I'm 68 years old, and I've lived in Charlotte, North Carolina, for most of my adult life. For 37 years, I ran a small CPA firm. Nothing glamorous, just me and 2 assistants, helping ordinary people navigate the tax code without losing their minds or their savings. I retired 3 years ago with a clean record, a solid reputation, and more money than I'll ever spend. I thought retirement would be the quiet chapter. The chapter where I finally had time to fix broken things. I should have been more careful about which broken things I chose to fix. The house at 4712. Cedarwood Lane used to be mine. I bought it back when the neighborhood was still mostly young families and modest ambitions. Raised my daughter Tara there. Painted every room myself. Replaced the gutters twice. Learned more about plumbing than any non-plumber should ever know. 2 years ago, when Tara married Derek Hartley, I signed the deed over to her as a wedding gift. My attorney at the time raised an eyebrow. I told him it was a gesture of love. He wrote it up anyway because that's what attorneys do. They follow instructions and let you learn from your own decisions. Derek Hartley is 41, sells commercial real estate, and carries himself with the confidence of a man who has never seriously failed at anything, which means he has no real understanding of failure. Calculated, handsome, expensive haircut, firm handshake. Opinions about wine that suggest one magazine article studied very carefully. Within the first month, I noticed the way he looked at me. Not at me, through me. The way you look at furniture you didn't choose. Polite enough in company, but the politeness had the texture of effort. He never once thanked me for dinner, not once in 2 years. I cooked 3 or 4 times a week. Nothing fancy, but real food. Roasted chicken, soup from scratch, the kind of cooking that takes time and attention. Tara would say, "This is great, Dad," and Derek would already be looking at his phone, fork moving automatically from plate to mouth. I told myself it was generational. I told myself a lot of things. He rearranged the living room furniture 6 months in. Didn't mention it, just did it. My reading chair, a leather wingback I'd had 15 years, ended up in a corner where afternoon sun would ruin it. I moved it back. A week later, it was in the corner again. I left it. The cough started in December. Dry winter, forced heat, nothing serious. My doctor checked it, found nothing. But every time I coughed in that house, Derek looked up. Not with concern, with irritation, like a clock ticking in a room where someone is trying to concentrate. I want to be fair to my daughter. She wasn't always this version of herself. Sharp, funny, loyal to the point of stubbornness. Called every Sunday from college just to talk. A gift for observation and the vocabulary to do something with it. Somewhere after she met Derek, the Sunday calls became shorter, then occasional, then stopped. She stopped finishing her own sentences when he was in the room. She'd start a thought, glance at him, read something in his expression, and redirect. It was subtle enough that if you named it, she'd tell you that you were imagining it. The Monday evening in early February started like most evenings. I was in my bedroom with the door slightly ajar. A habit, not an invitation. Working on an old Longines from 1962 that I'd picked up at an estate sale the previous weekend. The mechanism was seized with old lubricant, and I was cleaning it with the kind of focused patience the work requires. You can't rush a seized movement. You take it apart piece by piece, clean each component under magnification, reassemble with fresh oil, and either it works or it doesn't. There's a clarity to it that I find useful. I heard Derek's voice from the kitchen. He wasn't shouting exactly, more the volume of a man who has stopped caring whether he's heard. "Tara!" A pause. Cabinet closing. "I need you to hear me on this." I kept my hands on the watch. The balance wheel sat in my tweezers, delicate as a held breath. "That man needs to go." Another pause, and then, with the casual precision of someone stating an obvious fact, "Get your sick old fool of a father out of our house before he ruins everything for us." I set the balance wheel down on the velvet pad, very carefully. Tara's voice, when it came, was quieter. I had to concentrate to catch it through the wall and the distance. She said something about timing, then something that might have been an apology directed at him rather than a disagreement. Then footsteps in the hallway. A soft knock at my doorframe. Tara stood in the opening. She looked the way people look when they've just done something they're going to try very hard to reframe as reasonable. She was wearing the expression of someone delivering news they've already convinced themselves is neutral. "Dad," she paused, "maybe it would be better if you had your own space. For a little while." I looked at her, then at the long jeans on the velvet pad, mid-repair. 2 years of trying to be invisible in a house I once owned, and here we were. I picked up my loupe, examined the balance wheel under magnification, not because I needed to, but because it was something to look at that wasn't her face. "All right, Tara," I said. My voice came out level. "Give me until morning." She blinked. She'd expected tears, argument, outrage. The calm confused her. "Dad, Until morning," I said again and went back to the watch. She stood in the doorway a few seconds longer, then left. I listened to her footsteps retreat down the hall. The television came on in the living room. I sat very still with the 63-year-old watch mechanism in my hands and let the situation arrange itself clearly in my mind. I set the loupe down, reached for my notepad, and started writing. I didn't sleep that night. That's not entirely accurate. I didn't try to sleep. Sleep wasn't what the hours were for. By 10 o'clock I had the relevant documents spread across the bedspread. I'm old-fashioned enough to keep physical copies of important papers. 37 years of advising clients about documentation habits means you develop some of your own. Trust account statements, bank records for the last 3 years, the deed of gift from the house transfer. 3 pages, notarized, completely clean, and completely irreversible. 2 credit card statements for the joint accounts I shared with Tara, and a yellow legal pad where I began running numbers. The monthly transfer to Tara's account, $4,500, set up 18 months earlier after Derek's business had a rough quarter, and Tara mentioned, with the specific casualness of someone who has rehearsed the mention, that things were a little tight. I hadn't asked questions, just set up the transfer. 18 months at $4,500, $81,000, plus $14,200 for a kitchen renovation, plus $8,600 for a week in Maui, business class because Derek's back condition made Coach genuinely uncomfortable, plus $6,800 in various amounts when the word temporary appeared in a sentence and I chose to believe it. Total, approximately $110,600 over 2 years. I stared at that number for a while. Then the second column, what I owned unambiguously as trustee of the Montgomery Family Trust, $15.2 million, 37 years of modest income invested carefully, some fortunate real estate decisions before Charlotte became expensive, and the kind of patient compounding most people understand in theory but don't practice. Nobody gave it to me. It was mine entirely, with my name on every document as both grantor and trustee. I drew a line under both columns. I thought about a specific afternoon, maybe 20 years back, Tara, around 18, struggling with a calculus class. She'd called me from school in a state of careful, controlled panic. She asked if we could work through it together that evening if I wasn't too tired. 3 qualifications in 1 sentence, which was how she apologized for needing things even when needing them was completely reasonable. We sat at the kitchen table until nearly midnight. When she finally got it, really got it, understood the logic underneath the mechanics, her face did something I've never been able to describe accurately. It was the look of someone discovering they were more capable than they'd believed. I was proud of that evening in a way I couldn't name anything else quite matching. That was my daughter. I thought about meeting Derek. Tara had been dating him 4 months, brought him to Sunday dinner with the tension of someone who wants 2 things to go well and isn't confident they will. Charming, attentive, asked about my work with what seemed like real listening. I'd thought, all right, Maybe. The turn was visible only in accumulation. The attentiveness faded. The questions stopped. Derek relaxed into his actual self. A man who needed to be the most important person in any room and found even quiet, geriatric competition threatening. I understood it clearly by 3 in the morning. I made coffee at 6:30. Stood at the kitchen window looking at the oak I'd planted when Tara was 7. February, the garden beds empty, the oak entirely indifferent to the situation. Tara came downstairs, stopped when she saw me at the window. She had the expression of someone who'd steeled themselves for a specific conversation and wasn't certain it was still the one coming. "Good morning," I said. "Dad, there's coffee?" She poured a cup, sat at the counter, and tried to read me. Came up short. By 7:15 I was packing. 12 watches, each in its sleeve, wrapped in bubble wrap, into a cardboard box I'd kept in the garage for a month without knowing why. Now I did. 2 suitcases, clothes, documents, the legal pad, laptop, the watches, reading glasses, tools, everything that mattered fit in 3 containers. The rest was furniture. Tara came upstairs while I was closing the second suitcase. She stood in the doorway again. Same position as the night before, different expression. Last night had been apology in advance. This morning was something closer to disbelief. "You don't have to do this today," she said. I looked at her. "I do, Tara. Today is exactly right." "Dad!" She came a few steps into the room. Her voice had a quality I recognized from when she was young and genuinely uncertain. Not performing uncertainty, but actually feeling it. "Where will you even go?" "I've looked at some options." This was technically true. I had looked at several furnished apartment listings during the night on my phone, between columns of figures. She stood there while I set the box by the door, searching for the sentence that would produce a different outcome without requiring her to reverse anything she'd already committed to. "Tara, you asked me to leave. I'm leaving. Those are the same thing." Derek was not visible during any of this. Courtesy or cowardice, I didn't bother determining which. The cab appeared at 8:47. I put my things in the trunk and got in. The house looked the same from the street. Same oak, same paint. Tara stood on the front step and raised one hand. Not quite a wave. I raised mine back. I took out my phone and dialed First National Bank of Charlotte. Before the cab reached the end of the block, someone asked how they could help me today. "I need to make some changes to my accounts," I said. "Quite a few changes. I'd like to come in this morning." A pause. The neighborhood scrolled past. Dry cleaner, coffee shop, the elementary school. They had a manager available at 10. "Perfect," I said. "I'll be there." I looked out at Charlotte moving past the window and thought about the Longines, sitting half-repaired on a velvet pad in a room that was no longer mine. The cab moved. My phone was already open to the next number I needed to call. Some things couldn't wait. The apartment on Tryon Street was on the 19th floor, with a clear view to the uptown skyline on good mornings. A furnished rental at $3,200 a month. My landlord presented the number with the careful expression of someone bracing for negotiation. I just signed the lease. The building had a doorman, a gym I had no intention of using, and walls that didn't belong to anyone I was related to. That last part was more of a luxury than I'd expected. The next morning I was at First National Bank of Charlotte by 9:15. I'd used this branch for 11 years. The branch manager, a careful man named Henderson with reading glasses he kept on a cord around his neck, came out from his office when he saw me waiting. We shook hands. I told him what I needed. The joint credit card first, limit of $25,000, current balance of $7,340. I paid my portion, $2,100, which represented my actual charges over the past 3 months, and removed myself as a co-applicant. The remaining $5,240 stayed on the account as Tara's sole responsibility. Henderson typed this in without comment, though his expression suggested he wanted to say something. He didn't. Then the standing transfer. $4,500 a month, automatic, had been going to Tara's personal checking account for 18 months. I asked him to cancel it, effective immediately. Henderson set down his pen. "Mr. Montgomery, are you certain about this?" "Absolutely." The transfer was set up as a recurring. I understand how it was set up, Tom. I set it up. I kept my voice pleasant. Please cancel it. He nodded and typed. Then I asked for 36 months of account statements across all my accounts, checking, savings, and the trust distributions. He said that would take a few minutes. I said I'd wait, and went to sit in one of the chairs along the wall and looked at my phone. A text from Tara arrived while I was waiting. Dad, can we talk today? Henderson returned with a thick envelope of statements before I'd decided how to answer. I put my phone away. From the bank, I walked 3 blocks to 230 South Tryon and took the elevator to the 5th floor. Suite 510. Raymond Castle, attorney at law, estate planning, trusts, and probate. Found him through Martindale Hubble, which rates on peer reviews rather than self-promotion. His reviews mentioned precise and direct, with notable consistency. Those were the words I was looking for. His waiting area had 2 chairs, a small table with no magazines, and a receptionist who asked for my name and offered nothing else. Castle was younger than I had expected. Late 40s, lean, with the focused attention of someone who charges by the hour and means it. What can I do for you, Mr. Montgomery? He didn't waste time on small talk. Neither did I. I gave him the short version. Separated from my daughter and son-in-law, had transferred the family home via deed of gift 2 years ago, now lived separately. Wanted to understand my legal position. He listened without interrupting. When I finished, he asked 3 questions. The deed transfer date, whether any written agreement accompanied the gift, and whether I was the grantor or trustee on the family trust. I answered all 3. The deed of gift is a completed transaction. North Carolina doesn't allow revocation after delivery and acceptance, absent fraud or undue influence. The house is your daughter's. That won't change. I'd already suspected as much. And the trust? You said you're the trustee. Grantor and trustee. I set it up about 15 years ago. My daughter is the sole named beneficiary. Castle nodded slowly. As trustee, you retain full discretionary authority over distributions. You can modify terms, change beneficiaries, amend the trust entirely, assuming it's revocable, which I'd need to confirm. It was. Then the $15.2 million is under your complete control. You understand, your daughter still has a claim at your death if she's named beneficiary. I understand. I want to change that, among other things. He looked at me for a moment. I had the impression he was recalibrating something, updating his initial assessment of why I was there. Changing beneficiaries is straightforward. Draft an amendment, execute, file. A few weeks. I'll need the original trust documents. Do you have them? I put the folder on his desk. He opened it, scanned the first few pages, then looked up. This is well drafted. A slight pause. Did you do this yourself? I had help, but I read every word. Something that might have been respect crossed his face briefly, and then returned to wherever lawyers keep such things. We spent another 40 minutes on the will. The existing one left everything to Tara outright, and he walked me through the options for changing it. Clear, without embellishment. By the end, I had a picture of what was possible and what wasn't. His fee for the consultation was $450. I wrote the check. He walked me to the door himself, then paused. Mr. Montgomery. He picked up a manila folder from his assistant's desk. She'd apparently left it there during our meeting. There's one more thing I think you should be aware of. He handed it to me. Inside was a single-page document, a printout from what appeared to be a county property record search. Your son-in-law applied for a business loan approximately 2 months ago, $890,000 from Mecklenburg Regional Capital. Castle's voice was even. The collateral he listed in the application was the anticipated inheritance from your estate. I read the page. Then I read it again. He used my name, I said. He listed you as a financial reference and described the inheritance as a documented certainty. Castle watched me carefully. I thought you should know before we proceed. I stood in the doorway of Suite 510 with a manila folder in one hand and the bank statements in the other, thinking about a man who had called me a sick old fool and then borrowed $900,000 against my death. I put the folder carefully under my arm. Thank you, Raymond, I said. I'll be in touch. I walked back to the apartment. 19 floors up, coffee from the machine in the kitchen, and I sat at the table with Castle's folder open in front of me and tried to decide what exactly I was feeling. It wasn't anger. Anger requires surprise. This confirmed something I'd sensed without specific evidence to name. Derek Hartley looked at other people's assets and calculated. He'd looked at me and calculated. The number was bold. I'd give him that much. I refilled my coffee and made a list. I've been making lists since my early 30s. A professional discipline, not a quirk. Break the problem into components. Identify what you know, what you don't, what you can control. Work through it in order. What I knew, Derek had borrowed $890,000 using my anticipated death as collateral. I had not authorized this. What I didn't know, whether my name appeared on actual signed documents and whether the first payment had been made. What I could control, everything involving my own assets. What I couldn't, Derek, Tara, or the loan. I called Castle's office and left a message asking him to find whatever was publicly available about the Mecklenburg Regional Capital Loan. Then I called a number from a brief online search. Cindy Voigt, a financial forensics CPA whose firm handled complex asset restructuring. Castle's office had mentioned her name. I left a message. That evening, I spread the bank statements across the kitchen table and went through them page by page. 18 months of $4,500 transfers, cross-referenced against the credit card statements. The pattern was clear. Every time Derek had a cash flow problem, slow quarter, overdue vendor, money moved from my accounts to theirs. Never framed as a loan, always framed as help. The word temporary appeared in Tara's texts with the regularity of a term of art, just not one that held up in any document I'd reviewed. Several days passed. I found Stillwater clocks on East Trade Street, where a man named Victor ran the bench with the silence of someone who understood that clocks require concentration. I brought him 2 pieces needing work I couldn't do without proper equipment. He'd have an estimate by Thursday. I did not call Tara back. She texted twice, first asking if I was all right, then 3 days later, letting me know Derek had tried to reach me. I read both and put the phone down. Cindy Voigt called Wednesday morning. Brisk, precise, asked exactly the right questions. I needed an independent review of all financial flows between my accounts and my daughter's household over the past 2 years. Structured to be legally presentable, if required. Her rate was $280 an hour, 12 to 15 hours estimated. I told her to begin. Castle called that same afternoon. I have some information on the Mecklenburg Regional Loan, he said without preamble. Go ahead. The loan was approved 8 weeks ago. Principal of $890,000. Interest rate of 7.4% over a 5-year term. Monthly payment is $17,640. A pause. Derek listed anticipated inheritance from the Montgomery Family Trust as a primary asset in his application. He described the trust as having a current value of approximately $15 million. That's reasonably accurate. The problem, Castle continued, is the payment status. The first monthly payment was due 3 weeks ago. According to county records and what the lender's representative has filed, it hasn't been made. I thought about that. $17,640. 3 weeks overdue on a loan taken out against my anticipated death by a man who had been receiving $4,500 a month from me until 10 days ago. The lender will have contacted Derek directly about the missed payment, Castle said. Standard procedure. They'll give him a grace period, typically 30 days from the due date before they initiate formal default proceedings. So he has about a week, give or take. I looked out at Charlotte's skyline, the city doing its ordinary afternoon business, entirely unaware that somewhere on Cedarwood Lane a man was running calculations he wasn't going to like. Raymond, let's move forward on the will amendment and start the trust modification. I can have drafts by end of next week. Good. That evening I was at the kitchen table with a small pocket watch, a Hamilton from the 1940s that I'd bought at an estate sale a week before everything fell apart, when my phone showed a message from a number I didn't have saved. I opened it. It was Barbara Ellis, my neighbor from across the street on Cedarwood. I'd known Barbara for 22 years. She was 71 years old, lived alone, and paid more attention to the neighborhood than any security camera. Her message was brief. Ralph, hope you're doing okay. Saw Derek had a visitor this evening. Man in a suit, briefcase, stayed about an hour. Tara looked upset when he left. Just thought you should know. Take care of yourself. A man in a suit with a briefcase. 1 hour. Tara upset when he left. I had a reasonable hypothesis. I typed back, "Thank you, Barbara. Please don't mention you texted me." She replied with a thumbs up in under 30 seconds. I set the phone down and returned to the Hamilton. The mainspring was intact, but the escapement needed cleaning. Old oil, congealed to the texture of syrup, gumming the works. The solution was simple. Disassemble, clean each piece individually, reassemble with fresh lubricant. The watch didn't need a new mechanism, it just needed someone to take it apart carefully and put it back together correctly. I thought about the $890,000 loan. I thought about the man in the suit. I thought about Derek Hartley, who had called me a sick old fool and then borrowed nearly $1 million against my death, and who was now sitting in the house I used to own with a loan representative, explaining the consequences of a missed payment. I thought about what Castle had told me, and what Cindy Voigt was building, and what the trust documents said, and what a will amendment could accomplish. By the time I finished cleaning the escapement, I understood exactly what the next step was. Not all of it, not the whole picture, but the next step. That's all you need to begin. I put the Hamilton back together, wound it gently, and set it on the table. It ticked. Castle called me 2 days after Barbara's text about the man in the suit. The visitor to Cedarwood Lane was a collections representative from Mecklenburg Regional Capital, he said. I confirmed it through the lender's public filing. Derek missed the first payment on the $890,000 loan, $17,640, 31 days overdue. The lender has initiated formal default notification. What are their options? They can accelerate, demand full principal immediately, or proceed with standard default. Either way, Derek is in serious trouble. The collateral he listed was the anticipated inheritance from your estate. Since the trust is revocable and you're the trustee, that collateral is effectively worthless to them, meaning they lent $890,000 on nothing. They're going to want to talk to you at some point. They can talk to you. That's what I was going to suggest. I thanked him and ended the call. Then I made fresh coffee and stood at the kitchen window for a few minutes, looking at the skyline and thinking about the particular mathematics of Derek Hartley's situation. He had borrowed $890,000. His monthly payment was $17,640. Without the $4,500 monthly transfer from me, which he'd apparently been factoring into his cash flow, he was short on his first payment. Now the lender was at his door. I thought about Derek standing outside my apartment door 2 weeks earlier, the confident sales posture, the uncertainty underneath it, the man who needed to be the most important person in every room, standing in a hallway where no one would let him in. It was the following afternoon when Tara called. I was at Stillwater Clocks, watching Victor work on one of the pieces I'd left him, a Patek Philippe pocket watch from 1957 with a cracked mainspring. Victor worked with the economy of movement that comes from doing precise things for a long time. He didn't talk much while he worked, which I appreciated. My phone buzzed on the workbench beside me. Tara. I stepped outside. Dad. Her voice had a different quality. Not the tight, controlled reasonableness from before, but something more exposed. I need to tell you something. Go ahead. A pause. Then, I'm pregnant. I said nothing for a moment. The street outside Stillwater ran quiet in the mid-afternoon lull, just a delivery truck idling at the corner and the distant ordinary sounds of the city. When did you find out? I asked. About 3 weeks ago. 3 weeks. I'd been out of the house for nearly 4. She'd known while asking me to leave, or found out in the days after, and said nothing. Why didn't you tell me sooner? I asked. Not accusatory, just a question that deserved an answer. The pause was longer this time. We wanted to tell you at dinner, but everything happened so fast, and... Tara? I kept my voice even. The dinner you're describing didn't happen. I was asked to leave before any dinner. Silence. I'm glad for you, I said. Whatever else is true, I'm glad about the child. But that doesn't change what happened, or what I need to do now. Dad, we need help. Derek's business. I know about Derek's business situation. I let that land for a moment. All of it. Another silence, longer this time. I'm not going to discuss this on the phone, I said. Take care of yourself, Tara. That matters. The rest we'll address through the proper channels. I went back inside. Victor had the Patek Philippe movement on the bench, the cracked mainspring in a tray beside it. He looked up. Nice piece. It is, I said, and that was the conversation. That night, at my kitchen table, I had the Patek Philippe movement in front of me on the velvet pad. Victor had done the heavy work, and I was finishing the reassembly. The mainspring was replaced. Everything else was original. I worked with my loupe, fitting the tiny components back in the sequence they'd been designed for, a sequence that hadn't changed in 68 years. I thought about the child, a grandchild I hadn't known was coming, who would arrive into a situation I hadn't chosen and couldn't fully control. I thought about what it meant to be angry at someone and simultaneously glad that someone was going to exist. The two things weren't contradictory, they were just true at the same time. Around midnight, I set the movement aside and picked up my notepad. I had a list going: the trust amendment, the will revision, the ongoing financial documentation from Cindy Voigt. I added a line: grandchild, separate provision, to be determined. The next morning, I found the envelope on the floor inside my front door, slipped under by the building's mail service. Return address, a law firm downtown. Pierce and Whitmore, attorneys at law. I opened it at the kitchen table with my coffee. Derek and Tara Hartley, through their attorneys, were filing a civil claim. The substance: Ralph Montgomery had made repeated oral assurances of ongoing financial support to his daughter and son-in-law. These assurances, combined with 18 months of documented financial transfers, constituted an implied contractual obligation under North Carolina law. They were seeking a court order requiring continuation of the $4,500 monthly transfer, plus reimbursement of costs. I read it twice. Then I called Castle. I have the claim in front of me, I said when he answered. I received a copy this morning as well. His voice was dry. It's a creative argument. Is it a strong one? No. No hesitation. North Carolina courts have been consistent on this. Voluntary gift transfers between parents and adult children, absent a written agreement specifying an ongoing obligation, do not constitute implied contracts. The transfers are documented in your bank records as gifts. There's no promissory note, no signed agreement, nothing in writing. So they have nothing. They have a filing fee and whatever they're paying Pierce and Whitmore. A pause. I'll need a retainer to respond. I'd suggest $15,000 to start. I told him to proceed. 3 weeks passed. Castle filed the response to Pierce and Whitmore, and the initial exchange of legal documents settled into the quiet, expensive rhythm that civil litigation moves at when one side has a strong position and the other has mostly hope. I used the time well. Cindy Voigt delivered her first report, 47 pages covering every transfer between my accounts and the Hartley household over 27 months. Total, $110,600. Each transfer categorized, dated, cross-referenced. Her conclusion on page 3. No documentation established any legal obligation for these transfers. They bore all the characteristics of discretionary gifts under IRS guidelines. That document went into a folder in my desk drawer, next to the trust amendment drafts Castle had prepared. The trust amendment had taken the most thought. Castle walked me through it at a second meeting, shorter than the first because I'd reviewed the draft myself and came in with specific questions. He looked faintly pleased, the way professionals do when a client actually reads the documents. The revised trust document, executed properly, signed in front of 2 witnesses and a notary, filed with the relevant county records, named Tara as the beneficiary of a specific fixed amount, $500,000, to be distributed outright upon my death. The remainder of the trust, $14.7 million as it stood at that time, was directed to the Charlotte Community Foundation, with one provision: a separate educational trust of $750,000 for any biological grandchild of Ralph Montgomery, to be accessible at age 25. I had not told Tara about the pregnancy provision. I didn't plan to. Some things didn't require announcement. The will followed the same structure, consistent with the trust, everything locked and documented. I was signing the final pages at Castle's desk on a Tuesday afternoon, with 2 of his staff serving as witnesses, when my phone showed a text from Tara. The hearing is set. Did you know? I finished signing, initialed where required, and put the phone away until I was done. The hearing in question had been scheduled by the court, a preliminary session to review the Hartley civil claim before any full proceedings. Castle had been notified a few days before and had apparently not yet informed me, when Tara somehow got wind of it first. The judge assigned was Howard Pierce of Mecklenburg County Civil Division. The hearing date a few weeks out. That evening, Barbara Ellis sent me a brief text. Saw a moving truck at your old place today. They're redoing the study. Tara looked tired. I read it and put the phone on the nightstand. Tara looked tired. Pregnant, her husband had missed a payment on an $890,000 loan, managing a civil case against her own father, redecorating a room in a house she'd been given. I tried to feel sorry for her and found the feeling available, but not simple. The next morning, Castle called with information I hadn't expected. I've done some additional research on the Mecklenburg Regional Loan, he said, specifically on the documentation Derek submitted in the application. And the collateral section lists the Montgomery Family Trust as a guaranteed asset. His voice was careful. There's a document in the application file. It appears to be a financial guarantee, bearing what is represented as your signature, Ralph, attesting that the trust would cover the loan in the event of default. I set my coffee down. I never signed any such document, I said. I know. Castle was quiet for a moment. The lender's representative filed it as part of their default proceedings. It's in the public record now. I pulled a copy. Can you send it to me? Already did. Check your email. I opened my laptop and found the attachment, a single-page document titled Montgomery Financial Guarantee. At the bottom, above a notary stamp, was a signature. It was meant to look like mine. I'd signed my name approximately 10,000 times, over 37 years of professional practice, and I knew my signature the way you know your own handwriting. Not as something you think about, but as something you simply recognize. That was not my signature. I looked at it for another 30 seconds. Then I closed the laptop. Raymond, I said, I want you to find me a document examiner. A certified forensic one, not a generalist. Someone who testifies in court. I know 2, he said. I'll make some calls. Do that. I sat at the kitchen table for a few minutes after the call, looking at nothing in particular. The Hamilton pocket watch I'd finished reassembling was on the shelf near the window, ticking quietly. Outside, Charlotte was doing its Tuesday morning things. Traffic, construction somewhere to the south. The distant machinery of a city that didn't know and wouldn't have cared about one forged signature on one financial document in a loan file at a regional bank. Derek Hartley had called me a sick old fool. Then he'd expelled me from my own house. Well, Tara's house, technically, but the distinction had felt minor at the time. And then apparently he had forged my signature on a financial guarantee and used it to borrow $890,000. The man had underestimated me on every count, which was, I had to admit, the sort of mistake that was very satisfying to watch someone make. Castle's office called back within the hour a certified forensic document examiner named Pamela Soto, who held credentials from the American Board of Forensic Document Examiners and had testified in 11 Mecklenburg County cases, was available for an initial consultation. Her rate was $350 an hour. I told Castle to schedule it. The civil case was Castle's to handle. I had other things to think about. I made fresh coffee, opened my notepad, and considered the particular problem of a man who forges documents and assumes no one will check. In my experience reviewing financial paperwork for people who thought they'd found clever workarounds, no one ever checks until someone does, and then they always wish they hadn't. The hearing room in the Mecklenburg County Courthouse was smaller than I'd expected. A standard civil session space, not a trial courtroom, with a raised bench, 2 counsel tables, and a gallery with maybe 15 seats, most of them empty on a Monday morning. Castle and I sat at the right-hand table. Derek and Tara sat at the left, flanked by their attorney. Gregory Shaw was everything Castle had implied: polished, precise, and clearly accustomed to courtrooms. He was somewhere in his mid-50s, gray at the temples, with the relaxed posture of someone who wasn't worried about the outcome. I watched him arrange his documents with the calm efficiency of a man who believed in the case he was about to argue. I'd read Shaw's reputation before coming. He was good. What his reputation didn't address, because legal reputation generally concerns itself with tactics rather than raw material, was the quality of the facts he had to work with. Derek looked straight ahead when he came in. He was wearing a suit I'd seen before, a gray one he favored for client presentations. He'd lost some of the polish, though. His collar wasn't quite right, and there was a tension in his jaw that the suit couldn't conceal. Tara sat beside him with her hands in her lap and her eyes on the table. She was visibly pregnant now. I noted this and put it where it needed to go, a separate consideration, not a factor in today's proceedings. Judge Howard Pierce entered, and the room went through its standing formalities. Pierce was in his mid-60s, efficient-looking with the manner of someone who had heard thousands of cases and had no patience for theater. I respected that immediately. Shaw opened first. He laid out the argument methodically. 18 months of documented $4,500 monthly transfers, consistent in amount and timing, constituted a pattern that a reasonable person would rely upon. Derek and Tara had made financial commitments, the commercial real estate loan among them, based on the reasonable expectation of that continued support. To withdraw abruptly constituted a breach of an implied obligation established by conduct. It was the best version of a weak argument. I'll give him that. Castle's response was shorter. He directed the court's attention to 3 points. First, no written agreement of any kind existed. Second, North Carolina courts had been consistent since Forsyth versus Forsyth in 1994 that voluntary parental gift transfers without written documentation do not create enforceable obligations. Third, the bank records Cindy Voigt had assembled showed each transfer categorized as a gift, with no corresponding notation of obligation or expectation of continuation. Castle submitted Voigt's 47-page report as Exhibit A. Shaw attempted a rebuttal, implied contract by conduct, promissory estoppel, reasonable reliance. Judge Pierce listened with the patience of someone letting a clock run out. When Shaw finished, Pierce looked at both counsel tables for a moment. Then he said, in the tone of someone stating the obvious for the record, "The transfers in question are documented as voluntary gifts. The plaintiff has produced no written evidence of any obligation to continue them. The defendant was within his legal rights to discontinue them at any time. Motion denied. He assigned court costs to the plaintiffs, $18,400. I didn't react. I'd learned early in my professional life that the most satisfying response to winning is restraint. I stood when required, said what was required, and walked out of the courtroom at Castle's side with my face composed and my hands steady. In the corridor outside, Derek caught my eye for the first time all morning. He'd been avoiding it in the room. Now, with the hearing over and the distance closed, there was nowhere else to look. His expression was something I hadn't seen on him before. Not the competitive irritation he'd usually aimed at me, but something rawer. He looked like a man who had just realized, with great clarity, that the thing he'd been underestimating had turned out to be something else entirely. I held his gaze for a moment. Then I looked away. Castle walked me to the elevator. When the doors closed, he said quietly, "I have something to show you." We went back to his office. He pulled up the commercial property registry on his computer and turned the screen toward me. I cross-checked the loan application documentation that Mecklenburg Regional filed in their default proceedings. He said, "The collateral documentation goes beyond what we discussed before. It's not just the trust listed as an asset." He pointed to a specific field on the screen. "There's a guarantee instrument, a signed personal financial guarantee, your name, your signature, attesting that you personally would cover the loan in the event of default." I looked at the document on screen. It was different from the page he'd emailed me weeks earlier. This was the full loan file, and the guarantee was embedded in it with apparent formality. Notary stamp, witness lines, the whole architecture of a legitimate document. "I never signed this," I said. "I know. I've pulled 12 other documents bearing your genuine signature. From the trust, from the property transfer, from county records. I'm not a forensic examiner, but even I can see the difference. He paused. This isn't just a misrepresentation of your assets to a lender. If the signature is fabricated, Derek submitted a fraudulent document to obtain a loan. That's a different category of problem entirely. I looked at the screen for another moment. Raymond, I said, how does North Carolina classify that? He looked at me steadily. Forgery of instruments. Under General Statute 14119. A felony. I didn't hurry. Hurrying, in my experience, is what people do when they haven't thought things through carefully enough in advance. I'd had several weeks with the knowledge that something was wrong with the loan documentation. The hearing had provided confirmation that the civil case was resolved. Now there was a different problem to address, and it would be addressed correctly. The following week I met with Pamela Soto, the forensic document examiner Castle had located. Her office was on the 4th floor of a building on East Moorhead Street. Functional, no decor beyond a framed certificate on the wall from the American Board of Forensic Document Examiners. She was direct, systematic, and explained her methodology before touching anything. She needed exemplars of my genuine signature, the more the better, and from varied dates to account for natural evolution over time. I'd brought a folder, trust documents, property records, IRS filings, professional correspondence going back 15 years, 43 separate signatures. She examined them at her workstation with magnification equipment, making notes on a pad beside her. Then she examined the guarantee document, printed from the loan file, compared against originals I'd certified as genuine. She worked for about 40 minutes without speaking. Then she looked up. The signature on this document was not written by the same person who signed these exemplars, she said. The pen pressure pattern is different. The baseline angle is off by approximately 12 degrees from your consistent baseline, and the letter formation in the surname shows a different stroke sequence than your established pattern. She paused. In my professional opinion, this is a simulated signature. Someone attempted to copy the general appearance of your signature without replicating the underlying motor patterns. Will you put that in writing? That's what I do, Mr. Montgomery. Her written report was delivered electronically 10 days later, 31 pages, methodical and precise. Her fee was $3,800 for the examination and report combined. She noted at the end of the report that she was available to testify if the matter proceeded to court. Castle filed the criminal complaint with the Charlotte Mecklenburg Police Department on a Wednesday morning, accompanied by Soto's report, the loan documentation, and my sworn affidavit that I had never signed the Montgomery financial guarantee or authorized anyone to sign it on my behalf. The detective assigned to the case called me 2 days later to confirm receipt and ask preliminary questions. I answered them clearly and without elaboration. The detective, a careful-sounding woman named Rodriguez, said the investigation would proceed and that she'd be in touch. That evening, Tara called. It was late, past 10, and the fact of the hour told me something about the state of things on Cedarwood Lane. I answered, "Dad." Her voice had dropped the careful management entirely. What was underneath was close to fear. "What did you do?" "I filed a criminal complaint, Tara, because someone forged my signature on a financial document." A silence, long enough that I could hear her breathing. "They could arrest him," she said, not a question. "That depends on the investigation. I didn't make that determination. I reported what happened. That's what you do when someone commits fraud using your name." "Dad, I'm 7 months pregnant." "I know." Another silence. Then, "Did you have to do it this way?" I considered the question. Derek signed my name to a document guaranteeing a $890,000 loan that he couldn't repay. He then used that document to borrow money from a bank. When the bank comes looking, they'll find a forged guarantee with my name on it and try to hold me responsible. "Yes, Tara, I had to do it this way." She didn't answer immediately. When she spoke again, her voice was quieter. "He said he thought you'd understand. Eventually." The sentence was so specifically wrong, so perfectly capturing Derek Hartley's method of thinking about other people, that I almost laughed. Almost. I understand exactly what he did, I said. That's the problem. I ended the call and sat for a few minutes in the quiet of the apartment. The Hamilton on the shelf kept its steady tick. Outside, Charlotte was doing what Charlotte does at 10:15 on a weeknight. Settling in, lights going off in the buildings across the way, the distant sound of the city reduced to its minimum frequency. Barbara sent a text 3 days later. Ralph, Derek left this morning with one suitcase. Tara's home alone, just letting you know. I read it twice. One suitcase. The man who needed to be the most important person in every room had packed one suitcase and left a 7 months pregnant woman in the house I'd bought 30 years ago and given away as a gift. I put the phone down and looked at the ceiling for a moment. Then I picked it up again and sent a text to Castle. Derek Hartley has apparently left the family home. Tara is alone. Does this change anything legally? Castle's reply came within 20 minutes, not with respect to the criminal matter, which proceeds independently. However, if she requests any support as a separate matter, that would be a different conversation. Your call. I sat with that. The investigation would take its time. Derek would eventually be found. Rodriguez had indicated he wasn't a flight risk, just someone who needed to process an uncomfortable reality. The legal process would proceed. What I did about Tara was a separate question. I picked up the Hamilton, turned it over in my hands, listened to the mechanism working inside. A watch doesn't know whether it's being admired or forgotten. It just keeps the time it was built to keep. I set it back on the shelf and reached for my notepad. There were decisions to make. I was going to make them carefully. Derek was found in Rowan County, about 40 miles north of Charlotte, staying at a motel outside of Salisbury. Detective Rodriguez told me this in a phone call on a Thursday morning, about 3 weeks after Barbara's text about the suitcase. He hadn't fled. She used that word specifically, and I appreciated the precision. He had simply been sitting in a motel room, apparently not doing very much of anything. She informed me that the investigation had concluded, that the forensic documentation from Pamela Soto's report was sufficient to support charges, and that Derek Hartley was being charged with forgery of instruments under North Carolina General Statute 14119, a Class 1 felony. The case had been referred to the Mecklenburg County Superior Court. Mr. Montgomery, she said, I want to make sure you understand that this process will take time. The court's calendar. I understand, Detective. I've dealt with complex timelines before. Of course, I just want to be clear that there's no guarantee of outcome. There rarely is, I said. That's fine. After the call, I sat at the kitchen table with my coffee for a long time, not thinking about anything in particular. The Longines I'd been wearing the night everything started was on the table in front of me. I'd been servicing it, cleaning the case, replacing the crystal. A small maintenance job, nothing major. The movement was solid, just needed attention. The bank moved faster than the court. Within days of the charges becoming public record, Mecklenburg Regional Capital's legal team was in contact with Castle. The Montgomery financial guarantee, they now understood, was a fraudulent document. Without valid collateral, the loan agreement was effectively voided, but the principal, $890,000, remained Derek's personal obligation. With his business already in default, and the commercial real estate market providing him no meaningful income while this was ongoing, Derek Hartley was, by any reasonable financial assessment, insolvent. Castle kept me informed without editorializing, which I appreciated. Summer moved through Charlotte the way it always does, heavy, slow, relentless. I spent more time at Stillwater clocks. Victor had located an Elgin pocket watch from 1923 that needed significant work, and we'd negotiated a reasonable price. I worked on it at my kitchen table in the evenings, the same way I'd been working on watches for 15 years, piece by piece in order, without rushing. Barbara texted occasionally with brief neighborhood reports. Tara's car was in the driveway most days. She appeared to have stopped working. She'd been a marketing consultant, part-time, from home. One of Barbara's texts mentioned that a younger woman had been coming by on Wednesdays, which I took to mean Tara had arranged some help. I was glad of that. The call came on a weekday afternoon in mid-August. Not from Tara, from Barbara, just a brief message. Tara had the baby this morning, a girl. Both doing fine. Thought you'd want to know. I read it twice. Then I set the phone down and went to the window and stood there looking at the skyline for a few minutes. A girl. I got dressed, went to First National Bank of Charlotte, and arranged a cashier's check for $50,000. I wrote a note on a plain card. This is for the child. Not from me to you, from me to her. There's a difference. I put both in an envelope and mailed it to 4712 Cedarwood Lane that afternoon. Tara called 2 evenings later. I answered on the second ring. She didn't say anything at first, just the particular quality of silence that belongs to someone who is trying not to cry and losing the effort. Then a sound that wasn't words. I didn't fill the silence with anything. I let it run until it found its own shape. "Thank you," she said finally. Her voice was different from anything I'd heard in it over the past several months, stripped of the management, the careful calculation, the performance of reasonableness. Just tired. Just her. "She's healthy?" I asked. 7 pounds, 4 ounces. She looks like... A pause. "She has your hands." I didn't say anything for a moment. "Get some rest," I said. "That's all you need to focus on right now." "Dad..." "Rest, Tara." I ended the call. Sat in the quiet apartment. The Elgin's movement was half assembled on the velvet pad, and I looked at it for a while without picking it up. A week later, Castle called with news I hadn't expected quite yet. Derek's new attorney, Shaw, had withdrawn, citing the conflict of interest created when the civil and criminal matters converged, had approached the district attorney's office with a plea arrangement. Derek was prepared to plead guilty to a reduced charge in exchange for no incarceration. The DA was open to it. As the complaining party, I was being consulted on whether I would support the arrangement. "What are his terms?" I asked. Castle read them. Guilty plea, 3 years probation, a fine in the range of $10,000 to $15,000, community service hours, no prison time. I told Castle I needed 48 hours. I spent the 48 hours thinking, not agonizing, just thinking. Walked along Tryon in the mornings, worked on the Elgin in the evenings, read through the complete case file as a whole for the first time. By the end of the second day, I knew what I wanted. I called Castle. "I won't oppose the plea arrangement," I said, "with 3 conditions." "Go ahead." "First, Derek signs a written statement acknowledging that the Montgomery Financial Guarantee document was fraudulent and that my signature on it was not my signature. The acknowledgement becomes part of the court record." "That's standard with a guilty plea," Castle said. "It would be in the factual basis." "Good." "Second, he signs a release of any and all claims against me, my estate, and the Montgomery Family Trust, permanently and irrevocably. That can be drafted as a civil settlement. I'll draw it up. Third, the probation includes mandatory participation in a financial management program, approved by the court." Castle was quiet for a moment. "That last one is unusual but not unprecedented. I can request it as a specific probation condition." "Request it." The plea hearing was scheduled for a morning in early October. I did not attend. Castle represented my interests through the documentation, and Derek's signed acknowledgement that the Montgomery Financial Guarantee bore a fabricated signature was entered into the Superior Court record. Terms: 3 years probation, a $12,000 fine, 200 hours of community service, mandatory financial counseling. Castle emailed me a summary that afternoon with 1 sentence added at the bottom, unusual for him. Clean outcome. I was at Stillwater Clocks when the email arrived, alone at the bench with the Elgin, working through the final assembly. The mainspring set, the barrel seated, the train wheels engaged. The escapement last, the part that regulates the release of energy, that makes the difference between a watch that runs and one that runs correctly. I fitted the escapement, checked the engagement, and wound the watch gently with the crown. It ticked, not the tentative, uneven tick of something that had just barely been coaxed back to life, but the clean, regular beat of a mechanism that had been properly serviced and was now doing what it was designed to do. I set it on the bench and watched it for a moment. Cindy Voigt sent her quarterly report 3 days later. The trust stood at $15.6 million. Dividends and distributions from the underlying investments had added $400,000 over the course of the year, despite everything else that had been happening. The financial world, as it tends to do, had continued operating on its own schedule. I filed the report with the others and updated my notes. Tara came on a Saturday about 2 weeks after the plea hearing. She called first, a brief call, just to say she was coming, and to ask if that was all right. I said yes. She arrived at 11. Earl knew to send her up. When I opened the door, she was in the hallway with the baby in a carrier against her chest, moving with the careful attention of someone carrying something small and precious in public for the first time. She looked different, not just the tired of new parenthood, but different in a way harder to name, as though something held tightly for a long time had finally released, and what remained was something closer to her actual face. "Come in," I said. She sat on the couch. I made coffee. We were quiet for a few minutes in the way that people are quiet when they're trying to figure out what the first words should be. She didn't apologize in words. That was the right choice. An apology here would have been too small, a sentence trying to cover something that needed more than a sentence. Instead, she lifted the baby from the carrier and held her toward me. "Do you want to hold her?" I sat down and took the child. She was small in the specific way that new things are small, more solid than you expect, more present. She had her eyes open, moving the way new eyes move, not focused on anything in particular, but paying attention to everything. I looked at her hands. Tara had been right about that. "What's her name?" I asked. "Clara." Tara watched me hold the baby. "Clara Ray." I didn't say anything for a moment, just held the child and let the room be what it was. "I haven't forgotten," I said finally. "What happened? How it happened?" Tara looked at her hands in her lap. "I know. But I'm still here," I said, "and I have time to see what comes next." She looked up. Her eyes were doing the thing eyes do when a person is working very hard to maintain composure and not entirely succeeding. She didn't say anything. I looked back at Clara, who was examining the ceiling with the concentrated attention of someone encountering ceilings for the first time. "She'll need a good library card," I said, "and someone to explain to her how compound interest works before she's 12. Those things I can manage." Tara made a sound that was somewhere between a breath and a laugh. We sat there for a while. The apartment held the particular quiet of a Saturday morning. Traffic sounds from below, the Hamilton on the shelf keeping its steady count, sunlight coming through the window at an angle that moved slowly across the floor. After Tara left, I went to the desk. The Elgin sat in its case, a 1923 pocket watch that had spent most of a century broken and forgotten, until someone looked at it carefully enough. I picked it up, let it tick against my palm for a moment. Then I set it back in the case, closed the lid, and went to make fresh coffee. Some things you can fix. Some things take longer. Some things you hold carefully and see what happens next, because you're still here, and the work isn't finished yet. That's enough. That's exactly enough. If you like this story, please like this video, subscribe to our second channel, and share your impressions in the comments. To listen to the next story, click on the field on the left. Thank you for watching.